Hello, everybody. This is Dustin with Utah News. We're happy to bring you another deep dive in our interview series. Today, we have Randy Parker, 14-year CEO of the Utah Farm Bureau, joined with Kent Singleton, who is the landowner, former vet as well from Vietnam. We thank you both for being on our show today. And this one is a striking matter. It goes into a lot of the property, kind of a theme we've had going for the past couple of weeks here on our show. And before I get into too much, I'll let you both introduce yourselves a little bit. Kent, if you wouldn't mind telling us a bit about you.
Thank you very much. It's a pleasure to be on your show. Thank you. My name is Kent Singleton, and I'm a property owner in Morgan County. And I've been a realtor for over 40 years. Uh, Basically, a little background story on this property is in 2019. My client asked me to make an offer on some property that was on the multiple listing. The whole world gets to see and make offers on those types of properties. And so we made an offer on the property. He got it under contract, and about five of us went up to Morgan County and did our due diligence. It's what's interesting is that within 10 days of our buying the property, and this is only 6 acres, okay, Morgan County had a council meeting. It's May the 21st of 2019. And this is easy to view. You can go to YouTube and ask for the Morgan County Council meeting, May 21st, 2019. And you can see what they had done regarding that. So they actually went through and named our property a park.
Wow.
Going, what?
Okay.
Okay. So we were not aware of this meeting, and you'll be able to see that they took at great lengths to make sure that we were unaware of this meeting, or somebody would have been there, for the number of us people that were involved in this. And nevertheless, they had the meeting, and we didn't learn about it until a year later. Nevertheless, yeah. So anyway, my client, he bought the property, and all of this stuff started getting on him. And he says, I can't handle this. I'm selling the property. He put it up on the KSL classifieds, and he did everything he could about selling the property. And when the people who were interested in buying the property went to Morgan County, they disillusioned them badly, and he wasn't able to sell the property. And so I bought the property. It was that during the course of us owning the properties that I came to realize this is my ancestors' property. This is the property that I had always heard about and never got to actually go see until he purchased the property, until we did what we did.
And just to specify, this is that property from, what is it, Taggart down to Hennifer, which covers that good span of the Weaver River area. Is that right?
It's a segment. Yeah, they call it a segment. They call it hen tag, Hennifer to Taggart.
Okay.
And I've got the Taggart location. The Hennifer entrance is like maybe 6 miles upstream, and all along the river there is where people put in the river. Like, for instance, the commercial outfitters they use that. They put their clients in the river. They rent property upstream to do this, so they had access to the river. They did whatever they had to do. They rent the property. They get permission and permits, and of course they have to get a license to do what they're doing, and at the property, and rent the property. And they do that and put in the river there, and then they get out on my property down 6 miles downstream.
Okay.
Unfortunately, they put it in at about six locations. And so, I mean, the outfitters tell me they have 500 clients a day. 500 clients. There's 10 outfitters that are currently registered. Now, that can be a lot of people. Well, it's a mass gathering because there's only one location that you can get out of that they say that you can get out of. Like at this council meeting, you know what they approved? They approved an 8-foot sign that to put in my driveway, and they installed an 8-foot sign that as the bottom of the sign, all the endorsements are Morgan County, Summit County, a list of the outfitters. I mean, that's a conflict of interest, isn't it? But they have a list. I mean, it's like, so everybody's endorsed on the signage, and it's an 8-foot sign that's in my driveway. It also includes DNR, DWR. It's the walk-in access program. The walk-in access program, the previous property owners of my purchasing the property, they had a contract with the walk-in access program. That's under DNR and DWR. Well, that means people may go fish and hunt and trap and do all of that on the property. Now, when I bought the property, they said, no, you must, and I got this in writing, they said, you must go put up a no trespassing sign. And you've got to protect your property. Well, what they've done is they continue to sell fishing licenses and endorse everybody that's right there on the sign in my driveway to use my property. They put duplicates of that sign, the 8-foot sign. They put it on state property at the entrance up in Hennifer, and they even hung it on the railroad trestle in Croydon. So I've got 3 within 6 miles, 3 signs saying, this is the route that we take. And this is what it is. Now, I understand that people need to get out on my property. I do. I get that, but not without my permission or a contract. But they ignore this anymore. For me, they have ignored it since 2019, and they continue to do it every year against me.
Well, thanks for going into that a bit, Ken. And just to kind of pull back for a moment here, because I know we've got quite a bit to get into, and that's a lot to cover anyway. So thank you for that. And to go in with this on Randy Parker here, as I mentioned before, 14-year CEO of the Utah Farm Bureau. But I understand you have some experience with this. We were talking about your morning walks in the cold weather here in Utah as well. But feel free to introduce yourself, and if you wouldn't mind speaking to what Kent had introduced us to already as well.
All right. Again, Randy Parker. My history is I'm a ranch kid. I was raised on a sheep and cattle ranch. We had property here in Utah and also in the Bridger Valley in Wyoming. So I started out a absolute believer in private property rights and the right to protect your property rights, because if we had trespassers for whatever reason, it adversely impacted our livestock operation. I'm also a believer in the U.S. Constitution. This Constitution is my pocket Constitution that I used to carry with me generally wherever I went, particularly when I was involved with Farm Bureau, because we were the advocacy group or the voice of Utah farmers and ranchers, and I was very proud of that period of time. I wrapped up my career working for a gentleman by the name of Donald Trump when he was in his first term. So I was honored to work for the President of the United States. So that's my professional background. I have been involved in this conflict between recreation and private property owners that own these streams that are part of their title and their survey, and they're paying taxes on it. And just from a background standpoint, Dustin, as you think about Utah, Utah is an interesting state. When we entered the Union, we had to give up the right to a very vast part of our lands. And that ownership by the federal government continues to this day, with 67% of the state of Utah either BLM Forest Service, parks, national parks, etc., that is owned and controlled by the federal government. Now, I'm not going to get into the details of this, but I think that violates the equal footing doctrine that the founders said each state would enter the union equal to the original 13 colonies. But that's another issue for another day. The reason I bring that up is the state owns an additional 7 to 8%. So about 3 out of every 4 acres, or 3 out of 4 acres of the state of Utah is owned and controlled by the government. Therefore, by definition, it belongs to the public. Well, that puts a mindset in people that come to Utah to visit or live here, that basically anything is open for whatever they want to do, whether that's hunting, fishing, hiking. And there's this mindset that your property is our property. And Kent is one of those guys that's experiencing that firsthand. And this flies in the face of the U.S. Constitution and the Utah Constitution that provides a foundation for property owners that says property shall not be taken. And the Utah Constitution even goes further. Article 1, Section 22 of the Utah Constitution says this: private property shall not be taken or damaged for public use without just compensation. Kent's is the exact problem of property. They maybe haven't taken it from him, but they're surely damaging it by using it without his permission and without compensation. So it's in violation of the Utah Constitution. Now that's just a get started, because now there's a whole lot of lawsuits and laws, Dustin, that have been passed at the federal level, at the U.S. Supreme Court level, that define what navigable for title is, and so forth. That we can get into more details as this discussion goes along. I'd be happy to get into some of those lawsuits and those court decisions, as well as what laws have been put on the books.
Absolutely. No, thank you for that, Randy. And as you mentioned with the Constitution, I mean, that was one of the founding factors of wealth for the American dream, was land ownership.
Absolutely.
So absolutely an important topic to go over. And
in fact, Dustin, this might be a good time. This might be a good time to bring a case into it, because you just hit on something that is absolutely fundamental to America and American property rights. And that was a case called the American Land Company, 1911. The U.S. Supreme Court said this: they underscored the importance of private property in America. It goes on to say, it is the responsibility of governments to ensure certainty of title because the general welfare of society is at stake. Now, Kent, is your county attorney or your county law enforcement, are they protecting your right as defined under the American Land Company case, that they are to ensure your certainty of title? They're violating this fundamental principle laid down by the U.S. Supreme Court more than 100 years ago. They are not ensuring your certainty of title, and that's a fundamental part of property rights in our Constitution. Sorry to butt in there, Dustin, but I thought that the timing of the American Land Company case for this discussion was very important.
that was a perfect segue. No, I'm glad you even mentioned that. And you had asked Kent about that too. I mean, in regards to this whole situation, give us a little bit of background. You talked about what they've done with the signs and some of the segues, and I've read in some articles that they want to come and bring some land surveyors out to define if it is actually your property. And yeah, I mean, that just doesn't seem reasonable to me at all. But going forward with this, what is currently going on with your cases and the situation at hand?
Well, let me mention here that Morgan County has denied me all administrative procedures. and they denied me internal affairs, and they denied me public review boards. I cannot even go. So, but what they did is they pointed me to that I needed to go to the property rights office. Now, the property rights office, we met yesterday because I was asking for records. And so the archives committee denied me records. I will appeal that again, but the issue is at hand. I've been at the property rights office literally for years. We've had 2 mediations. The most recent one is in September. The one, and what it is that they had to, and I asked for an AO, it's actually called an administrative procedure. And I gave them checks. They're $150 each. I gave them 5 of them because unfortunately there's 5 entities involved, government entities involved on my property. And I gave them that. They denied it. They said, no, we're done. They wrote me an email and we're finished. We did all that we can do. Well, I thought that you'd go to the property rights office and that's for mediation purposes, that you can ask for the surveys that you had mentioned. So there's 2 surveys. There's one in 1965 that was done. And then there was one in Morgan County that I had done. I've been denied them. And that's a public record. And I don't know what to say. I've also been denied. There was, when the deputy arrived at one time, it was that he had his body cam on and his dash cam on. And I've asked for the body cam and the dash cam. I cannot get it. They refused me the body cam and the dash cam of that incident. And that was on the 20th of August, 2022. That resulted in it's unbelievable what it resulted in. It actually, but the body cam speaks for itself. It is that the officer, there's a mass gathering on my property. What I had done was I had issued a friendly, no trespassing notification to 5 outfitters, commercial outfitters, within 10 minutes. Now, I no discussion with them. I just asked them if there's a discussion. I just give it to them. And then I moved on. Well, within 30 minutes of giving those notices, of course, they got they're the ones that called the Borden County Sheriff's Office. And all of this is on video. I want the videos and I want the dash cams. And what they had done is that on the video that I did get from them, one of them is that on video, the deputy looked at his land maps, and he says, yes, you own the property, but the county administration is not issuing trespassing citations to anybody. And he turned to the outfitters and says, are you okay with this? You're still working, you go ahead and do whatever you're going to do. Right in front of me. He physically stopped me from protecting my property, and he gave permission, and I want the dash cams and the body cams, all of them. They've not given me all of them.
Wow. You mentioned you're going to be appealing this. Is there a time frame on that, on when you have to have that appeal in, or?
Oh, okay. So it was yesterday when we had this meeting, and Randy was there with me as well. So what I clarified at that meeting is that I've been in mediation for years now, and the last one since September, and I still cannot get the public surveys, and I cannot get my body cam and my dash cam. And what value is that? I mean, they're doing eminent domain on me. You would think that they would be open to all of this. Now, the first thing that I did is my ancestors, this document right here is what they call a land patent. So the first thing I did is I introduced myself and I gave a land patent that was issued to my ancestors. President Franklin D. Roosevelt, he signed this, and what it is that he asked for them to. They needed a route to get from Utah to Wyoming, and they needed a gas station, a store, and they needed a campground there. So they gave them the land patent that included my property. It was 500 acres initially, and I got the remaining 6 because they needed it to build I-84. So when they built I-84, you lose your property. All that remains in my heritage is 6 acres, and they're now trying to do eminent domain on my 6 acres.
Now, Kent, could I add to your comments here, because you've just raised something that is very critical.
Thank you.
Eminent domain, in the case of running the highway between Utah and Wyoming and all of the things, when you think about the use of eminent domain for a public good, they can make that argument and at the time did in order to run that highway. But your property now is outside of any public need, and in fact, Dustin, it's important for your viewers to understand that Utah's eminent domain law is very explicit. Utah Code 78B6-501 establishes limitations on the use of eminent domain, and it says eminent domain may not be exercised for trails, paths, or other ways of walking, hiking, biking, equestrian, or other recreational purposes. Now, Kent has established in this discussion today that there is no other reason that Morgan County would be looking at his property except for a recreational purpose because of the thousands of people that loiter on his private stream bed while they're getting out onto the highway to depart. And the threat of eminent domain in his case is absolutely a violation of Utah statute.
Wow, I didn't know about that statute there. So thanks for explaining that to me. And I myself, being born and raised here, of course, we'd love to recreate in Utah, and I've been up there hundreds of times. So again, my apologies. But yeah, the crowds up there are massive. You get so many people on these floaties, and they're doing their kayaking and rafting trips, and it's a great place to be, of course. But as Randy pointed out, it is solely a recreational use. I don't see any other point to it.
No.
Have they cited any other reference of the use of the land that they're interested in it for?
No.
And as one being
They say it's for the public use. Okay, but
Okay.
I'm sorry, this is private property. But you know what crickets sound like?
Well, this may be, Dustin, a good time to segue into a discussion of the legal roller coaster that streambed property owners have been through in Utah for nearly 20 years. If you go back, and this was on the Weber River, just downstream from where Kent's property is, there was a case where a property owner had the county sheriff come and arrest trespassers that were stopped on his stream bed fishing. And there was a case in 2008 at the the Utah Supreme Court called Conatzer versus Johnson. The Utah Supreme Court in 2008 made this ruling. It's unfathomable to me, but they overruled the lower court that found them guilty of trespassing, and the Utah High Court, the Utah Supreme Court went on and said, we establish our own rule. Now, that was the court's exact wording. We establish our own rule. There is a public easement on Utah streams since the water belongs to the public, and that includes the right to walk on private stream beds. Now, a good friend of mine who has passed recently, Representative Kay McKiff, who was an attorney. I was born in Richfield, and that's the area that he represented. So we had a close kinship. He was an attorney and also served on the 6th District Court here in the state of Utah. And he expressed concern that a court would make its own rule. And he viewed that as an invitation to Utah legislators who are elected by the public to make policy. So in 2010, Representative McKiff introduced the Public Waters Access Act that is now today Utah Code 7329-201. And it was passed and signed into law by the governor. And what that does is that defines the public's right to use the public's water that runs across private stream beds, like Kent's case. That's the public waters that run across his private property that he's paying taxes on. And the Utah law was very explicit in saying it only allows incidental touching for safe passage across Kent's property and allows portage if there is an obstacle. Those are the incidents that allow the public to stop and walk on his property, and that is explicit. Now, also important here is an angler coalition challenged that in a case called Victory Ranch on the upper Provo River, challenging the constitutionality of the Public Waters Access Act. And in that case, the Utah Supreme Court in 2023 found that the Public Waters Access Act is in fact constitutional, determined that there is no constitutional protection for the public to have a right to touch or walk on privately owned stream beds. And they further went on to tell the plaintiffs in this case that they have any further questions related to this issue directed to the legislature. Now, that's a pretty hard slap down, Dustin, I would argue.
I would say the same. And your statement that you said before is even baffling to me, that we make our own rule.
A court did that.
I don't know how that is legitimate or legal in any way. That doesn't, wow. And I know you've got experience in the past from other cases you've worked with as well, but please continue. You had something you were going to say.
I like you, I was baffled by an unelected appointed court, even at the highest court in the state, to say, because this hasn't been acted upon, we're going to make our own rule. Well, I absolutely pat Kay McKiff on the back and, for saying this is an invitation for the elected policymakers of the state of Utah, elected by the public, to make policy. Bless his heart for doing that.
Absolutely. And wow, I mean, there's a lot going inferred with that too. And any precedent that were set by these previous cases, I mean, they should be, it should be open and closed by now. It should be just settled and here's your property. So
well, if you think about this, one of the issues that really comes into light here is Kent. What they've told you is they're not going to enforce the trespassing laws and the Public Waters Access Act and incidental touching because the law is unsettled, correct?
Correct. So that's why they have said that if the sheriff issued a citation for trespassing on property, he probably would not enforce it, but it would be his decision to do that.
So what they're doing is they're telling law enforcement that if they cite somebody for trespassing, for example, on Kent's private property, they're not going to prosecute it anyway. Am I right there, Kent?
That was the bottom line. Yes.
Okay. And this is not the only case, Dustin, that this is happening. This is also happening on the Provo River. And what they're arguing is that this is unsettled law. Now, how can this be unsettled law when the Public Waters Access Act specifically defines incidental touching and moving around obstacles? That there is no way that that's unsettled. And Utah's criminal code, Dustin, says this in 76-6-206, offenses against property. Private property is defined as the bed or bank of a non-navigable freshwater stream or river that flows through privately owned land. Is there any ambiguity to that, Dustin, in your mind?
Quite a bit. I was about to read off a segment from one of the Salt Lake Tribune articles that was in regards to this as well, that states that the public has the right to float down a navigable river. And it goes into a quotation here of a term with some with knowledge of the troubles doesn't fit this section of the Weber River in general. And that article goes in to say the same thing. I mean, that is completely just clear as mud in my.
You got that right.
Oh,
Well,
you mentioned the Provo River as well as having some similar issues. Is there
yes.
any relation in some of these filings that are happening in the courts?
Yes, in fact, there's a gentleman on the Provo River that is going through exactly the same issues. In fact, what has become a fundamental claim by those that want to recreate and walk on somebody's private property are arguing that that this is navigable for title. Okay, this is the crux of this legal battle that has been going on, is that this is navigable for title. And what that means is if a stream was used or useful for trade or travel, both commerce and travel, public travel, at the time of statehood, for Utah, that would be 1896. What that river was used for at that time when we were granted statehood, if in fact it met that definition, then it was the public's. Therefore, the public had the right to float or use that stream. Now, the Jordan River is a navigable stream. The Bear River is a navigable stream. Parts of the Colorado and Green are navigable streams. But what we're getting down to here is some of these little bitty streams that, was the Weber River ever used for trade and transportation in order to establish that high standard? Now, Dustin, this may get down into the weeds a little bit, but the U.S. Supreme Court has spoken on defining navigable for title. And they have expressed this 3 times now to give definition to what it takes for the state to claim that property as state property. Oklahoma versus Texas, 1922, the U.S. Supreme Court declared, disregard the temporary high water and consider conditions prevailing only at the greater part of the year. So what that means is they had to have used it for trade or transportation in its ordinary and natural condition, not just during high water. Like on the upper Weber River, what they would do is they would cut railroad ties to build the railroad, and they would dam up the river, and then they would put these ties down there into that area. And when spring high water, when the snow melted, they would fill up a reservoir and float these logs, and then they would blow it up so it could run down the river so it could be transported. Now, is that in its ordinary and natural condition, or is that a temporary high water? The second case is United States versus Utah, and this is down along the Colorado River. And what this was the state's claim in what's that really exciting rapids on the Colorado River I apologize. It just
You're okay. I can't remember it at the moment either, but yeah.
But anyway, parts of the Colorado River, based on this case, are navigable for tidal, and parts are not, because they were not able to. They can use them today on wave runners and those kind of things, but at the time they couldn't use them because they were so dangerous.
Right.
So that case said the stream must have been used or susceptible of use in its ordinary and natural condition. Now, the one that I got involved with here just recently in 2012, I guess that's not real recent, but semi-recent, was a case out of Montana. The state of Montana claimed all of the rivers in the state under the navigable for tidal standard, and said they all belong to the state of Montana. And in doing that, they sent a bill for millions of dollars to a power generator that had built power plants on the rivers up there, and said, because we've owned these rivers, you're going to have to pay rent on them. And that went all the way to the Supreme Court. And the U.S. Supreme Court, in the PPL Montana versus Montana case, was very explicit. In fact, this gives you an idea. We participated in that when I was at Farm Bureau, and I was in the U.S. Supreme Court chambers for arguments on it, which was really exciting. Bless his heart, Senator Hatch was able to get me a seat in the U.S. Supreme Court to hear arguments on that, and I helped with this brief. But the outcome of that case was very important to the state of Utah, and as we're deciding what meets that standard, they went on and said, this is a quote, "It is well settled law and is based on a segment by segment determination to establish navigability for tidal." You can't look at a piece of the river, and this is one of those things that's frustrating to me. The Utah Supreme Court, when they did the Orange Street decision on the Upper Weber, when they blew up those dams and floated ties, they said that met the standard for that 1 mile segment. Well, then the Department of Natural Resources expanded that 20 miles each side, so they claimed 40 miles without that going through a segment by segment process that the U.S. Supreme Court has explicitly said had to be done. Not just take somebody's private property because the state said it met that standard. It is an explicit standard that the U.S. Supreme Court, in 3 very distinct decisions, has said this is what it takes to do that. And then if you throw in the America Land Company, that decision of the U.S. Supreme Court that said it is the responsibility of government to ensure certainty of title, what Utah is doing in making any of these claims is adverse to what the Constitution of the United States underscores.
Right. And like you had mentioned before, I mean, defining that segment of land in one thing, it's again, we will make up our own rule. They're defining whatever segment they want to just by their own ordinance. And, Kent, you'd mentioned that the DNR, DWR, and all of these other agencies are involved and have these signs out on the property here. So where do you see this going forward from here? And, any kind of help we can provide, how can we do so?
I think that the public needs to be aware. I think that they've been advertising that they can use people's, specifically my property, okay? They've been advertising it so clearly that they'll even put a sign on signs. There's multiple signs on my property, okay? But that 8-foot one happened in 2019 after we bought the property. What is that? How can that be? And then they've been acting on allowing everybody to do that. So they're giving. Is it my job to teach the public? I put signs up on my property identifying this, okay? And they're gone overnight. I put up a no trespassing sign. They're gone overnight. So we go to mediation, and to mediate this situation, I agreed that I would paint my property. Because you see, when you paint a property, you take this pristine piece of property that is beautiful, and then you have to go paint it orange to indicate, and that says on that 8-foot sign, unless it's, if it's painted, that's private property. Well, I mean, what can you do? So I painted the property, put up new signage, and did all of that. Within a week of our last mediation in September. And now there's things that was supposed to be the other side was supposed to do, all these other agencies, and none of them did anything. Do you know what the sound of crickets is? And that's where we're at.
And like you mentioned with the painting of the property, I know folks down in Texas as well, and that was a similar thing. You paint a post purple, and that's your no trespassing sign, basically. This is private property, get off. That leads into a question I have as well. I mean, denoting that they're making their own rule. I'm going to keep coming back to that just because I can't believe it.
That is unsettling, isn't it?
It really is. Another part of it too is the liability piece.
Yeah.
I mean, I can understand as the property owner, these people that are using it for recreation. It's a beautiful piece of land. But what does the liability segment say, and is that affecting this case, or any thoughts on that?
Well, and it's mentioned even in that meeting on May the 21st of 2019, the attorney says there is no insurance. The county has no insurance, but what they're doing is I have all the liability, 100% liability. Now, when we talk about numbers of these people, it was documented that there were 3,000 people before COVID. Before COVID, there was 3,000 people a day. It doubled during COVID. So, I mean, can you have 6,000 people on your property on a daily basis because they have to get out there? Because just downstream of there are these water irrigation devices, and they're not safe for you to float down there. Okay, so for safety reasons, they're getting out on my property, because if they go any further, it's scary. Now, mind you, there's dead bodies found on my property. Okay, clarify that. But I asked for an incident report, and no, they're not going to they won't give me the reports, the police reports regarding those incidences. There's so many people on my property. I just got to mention something too. It is the frontage road of my property says on all the police reports, my address is 1100 Dope Road. Dope Road. You know why? It's a river bar. All the beer comes down the river, okay? And they call it Dope Road. This is also where they do all the county's police officers. I talked to these police officers, and they said, yeah, I got my training about dope on Dope Road. That's where they go to train all of the police about Dope Road. My address is 1100 Dope Road, and there are hundreds of police reports, including dead bodies. They won't share them with me, but it's just the way it is. There's child abuse. Now, you think about this. I care about children. I care about children in alcohol, and I care about children in drugs. And this is one place that the children know that they can go there 24/7, 365 days a year and get their needs, whatever it is. That's a great meeting place.
And as you mentioned before, and I can attest to that, just being an avid outdoorsman in Utah myself, is just the amount of people. Right before 2020 happened, it was pretty average. It was still fairly busy, but as soon as 2020 happened and then on, it's an anthill anywhere you go. I try to just go take my dog up Mill Creek Canyon even, and there's 300 people in a parking spot, and I can't even get there. So it's a madhouse of people, and I can't imagine that it is your property, that they want to control it, but you have to pay the liability. It's a really bizarre series of events that's happening here, and Randy, it looked like you wanted to just comment on that.
Yeah, in just some thoughts just in bringing this all into your listeners and your viewers' minds is, private property, our constitutional right to private property is meaningless if settled expectations of ownership may be dashed at the whim of any branch of government. Kent understands that very well. The other part of it, county attorneys and law enforcement using the excuse that something is unsettled, in my mind, they're abrogating their oath and responsibility to protect the private property, the owners of private property. And then enforcing the Constitution and protecting certainty of title for people like Kent should be the obligation and a first obligation of local government. It brings me to, like I told you, Dustin, I'm a product of a ranch with property in Wyoming and Utah. Now I live on a 1/4 acre lot. How would the many of your viewers and listeners feel if their 1/4 acre lot had the trespass abuse that somebody like Kent has? That your right to lock your door and keep people from your home, or lock your gate and keep people from your property. How would they feel if law enforcement ignored people trespassing on your property, your 1/4 acre lot? I don't think people would stand for it. And they shouldn't stand for what's happening to Kent and other people like him that have private property they're paying taxes on and have the same expectations of government to protect their certainty of title. Thank you.
No, I couldn't agree more. And in that same aspect, I'm about a 1/4 acre lot myself. I'm just down here in the suburbs. But I remember not too long ago, there was a law that I believe was reversed. So don't quote me on this. But in regards to, say, a burglar coming on my property, they hop the fence, break their ankle, or my dog were to attack them in my yard, my property, I would have been liable. And I
Yes.
believe in some note that was reversed in some areas. I can't be sure. I'd have to look into it more, but I do remember that was a thing here in my area.
That's troubling.
Yeah, and
I
it's
mean,
it's happening everywhere. You have this kind of, you mentioned eminent domain before. I've noticed some freeway projects in my area where there've been families that recently paid off their home, and it was, well, here's an offer, either take it or it's going to be bulldozed.
yeah, exactly.
It's not uncommon, and it's scary. So like you mentioned, it's holding these representatives accountable. Call your legislature, get on the phone, and get involved to Utah in general. Be a part of this. And I definitely want to open it up to both your final thoughts here on what we can do moving forward with your case and in general.
Thank you very much.
Well, thank you, Kent. And in regard,
I would appreciate an opportunity to, what they say, pound the drum.
absolutely, no, by all means. And I wanted to tell you, I love the hat, by the way.
Well, thank you. I was hesitant. This is the first time I've worn it, but it is something that I was thinking about wearing yesterday at the committee meeting, and I didn't pull it off.
No, it suits you. I like the hat, and yeah, wear it proudly. And again, oh, feel free, Randy.
And my thinking is, for anybody in a position of responsibility, county attorney, law enforcement, whatever it is, to suggest that some law is unsettled for whatever reason that compels them to not enforce, or to say, well, you can cite them for trespassing, but I'm not going to take that into court and press it. There's something wrong with that when the laws of the state of Utah related to private stream beds are explicit. The criminal trespass code is explicit. That's a cop out, and it's a violation of their oath of office, and that's the discouraging thing for property owners that have protections under the Constitution.
Absolutely right. That is a disservice to their oath of office, and and they need to be held accountable. That goes back to a root of a lot of what we've been bringing up the past few weeks, is the accountability, making sure that these people that are in a place of power or supposedly voted on are held to that account and do your just service. Now, that being said here, Kent, what can we expect next from this case moving forward? What kind of time frame are we looking at? Because we definitely want to make sure we keep up to date on this and bring anything new to the listeners.
Well, I'm still trying to get the body cam and the dash cam concerning, and let me go, and I'll tell you what I'm adamant about this, okay? is that right there in my driveway on August the 20th of 2022, when the Morgan County Sheriff's Office told all the outfitters, they told the mass gathering of people who were there, who were yelling at my wife while she was changing out the batteries on my surveillance cameras, up there in my driveway. They were yelling at her. She could not use our driveway. It was jam-packed with people. Okay, yelling at her. So she walked around the property, and this is why I want the body cam, is that what they did is they gave her a retaliatory criminal trespass citation, seeking 6 months jail time and $2,000 fine. And we went through judicial court.
That was for walking on a railroad track, Kent.
Yes, that was walking for the railroad track. Mind you, if you may remember that the back of my property is a really an important location for double trestles, double tunnels. These are for the railroad. That tunnel that is used in the railroad's calendars. They put that location, that's very popular for all the railroaders. I'm a member of what they call the Golden Spike Railroad.
Right. Okay.
It's pretty substantial, the railroad for Utah. That location is very popular because it's an easy access. And you can go there and you get to see the double trestle, the bridge, the double tunnel, and all of that going on there. And I've been working with the railroad about on my property, because it's right there, that we accommodate those people who come from all over and to video and take pictures and all that of that location, because it's so popular. It's one of the most popular places I know of in Utah.
Yeah.
And so if I had a picnic table there, you know what I mean? And I just, let's make this comfortable for people to be there and to enjoy that opportunity.
They cite your wife on it.
They cited because she had to walk around the property. Now, there's no fences there between my property. let's put it this way. There's never been a fire on that property because my ancestors have maintained the property. You know, the railroads always cause fires, right? Yeah, I mean, it's from the trains, etc. There's never been a fire there. It's because my ancestors have maintained the property so that there's never been a fire. And so we can maintain the property, but we can't walk around the property and actually, you know, and not without getting a criminal trespass citation. Now, I need to say this for clarity purposes, is that I've been in touch with the railroad, and the railroad is adamant they had nothing to do with that citation. They put it in writing to me twice that they had nothing to do with that citation. My problem is with Morgan County. Morgan County issued, and we all know you can't do that. You know, a county cannot issue a citation without the property owner's permission. Well, they did in that case. But if they come into your house and they trespass your house, you have to give the officer permission to give them a citation for being trespassing on your property. It's that way in the rules again. State statute, that's the way that it works. Morgan, the railroad says, no, we never gave Morgan County that permission. And yet at the same time, they gave her the citation.
It's just absurd, and it's almost just a variation of abuse of power in a way. But yeah, Randy, please.
But they won't cite anybody for trespassing on his property. The same county officers that cited his wife for walking on a railroad track won't cite anybody for being on his property. Kent, how many of them have threatened you personally?
If I'm there, I'm threatened continuously.
Yeah, that's the point.
Every time I go to my property, I am threatened continuously. It doesn't matter.
The point. It's your property. They're not protecting your property rights, and then you're being threatened by those that are trespassing on your property. It's unfathomable. And then they cite your wife for walking around the mass gathering to get to your property. That's crazy.
Instead of the deputy helping my wife, because on the body cam, he identified, he asked who she was, and my one of my friends who was there says, well, that's Kent's wife, and he wouldn't help her through the mass gathering. He said, what you can hear on the body cam of him putting the plan together, because he knew that if she walked this way, because that's the way she was walking, she was going to have to walk around and touch on railroad property. He claimed that there was a no trespassing sign, the railroad no trespassing sign. He claimed that was there. So when we went to court, they fabricated the no trespassing sign from nearly a mile away. But what's interesting is about those no trespassing signs that the railroads put up, they have mile markers that are written on them. How many miles from Omaha there is that sign? Well, that indicated that it wasn't anywhere near our property. And of course, all she was trying to do was get back to her car and walking around the mass gathering. I mean, we weren't planning on staying there because we were obviously outnumbered. She was wearing a COVID mask. I was wearing the COVID mask. We were the only ones wearing COVID masks. And all of this going on is like, we wanted to get out of there. She walked around, and within 30 minutes, and it should be on that video that I've been trying to get on the body cam and the dash cam, is that when that information regarding that within 30 minutes, they gave her that citation. And of course, right in front of all myself and a couple of my friends.
That's
It was,
discouraging.
Yeah,
it was and we went to judicial court and they found her guilty. So what they do is they went to, we appealed it to district court. The district court, you will not believe what they had done. The very photograph that they had taken of her for being on the railroad track, now she wasn't on the track, but she was near it, okay? Because you have to go there, because mind you, there's a river between you and the track. So for her to walk around there, it was that photograph. When the deputy took that photograph, he cropped it so that you couldn't see the train signal. There was a train signals there. He cropped it down so you couldn't see the train signal because there was no trains. There was a signal saying all clear. And he cropped it from there. And then when he had taken that photograph, it showed the interior of the car. When he had taken the photographs, the interior of the car was shown. And then when it appeared in court, in district court, it was cropped again. There was no interior showing in the photograph that they presented to the judge. So it's like they keep changing the evidence in this, and they change, and then of course we already had him with the only no trespassing sign that he cited her for, that he claimed was there, was on the other side of the mountain. And
like with most anything else they have these days is let's keep moving the goalpost. You meant it to here, but wait, we're going to do this that you have to go again, and it's just unobtainable in most things. So with this appeal, then final thoughts here before we have to close out after the hour here. Is in moving forward with this appeal, is this going to be going to another rank, whether it's district or judicial or up against the Utah
well, no,
Supreme Court?
this will be just going to the committee, the archives committee.
Okay.
Because I want records of all of this. And they keep denying me records. Well, I'm going to appeal their decision yesterday, again, because you would think that if you leave the property rights office, who is supposed to be a neutral party helping you get documents so that you could be able to have a mediation with. So I've been in mediation with them for a couple of years now, and I have not gotten my documents. You would think that I would have documents. They have concluded that they're done with me. I got an email from them. They cannot help me any further. That was all that they could do. Well, I never got even my surveys. I never got my body cam and dash cam. What is their purpose?
Right. That's insane. And Randy, final thoughts from you here, and we'll let you about your day.
I would just like to see these elected and law enforcement officials do their job and enforce private property rights and honor the Constitution of the state of Utah and not use excuses like something is unsettled so that they can abrogate their responsibility. Thank you.
Well, thank you both for being here. I really appreciate your time in general. Again, I love the hat. Thank you for your service. Randy, thank you for being a part of this also. And you've both been great on the show. We'd love to hear some updates. Have a great Martin Luther King Day weekend, and stay safe out there.
All right. Thanks, Dustin. It's been great.
Thank you, Dustin.